morning, ladies and gentlemen, and welcome to ELCA's 10th webinar series on the theme of corporate liability and damages claims. My name is Nomasango Masiamoyo, and I am the coordinator of the Environmental Lawyers Collective for Africa. Joining me as your co-host today is Lucien Limoshe, who is the head of Defending Rights and Litigation here at Natural Justice. In the wake of increasing environmental challenges, the issue of corporate liability for damages caused by natural disasters has become more pertinent than ever. Today, we explore the complexities surrounding this issue, aiming to shed light on the legal landscape and the responsibilities that both the state and corporations bear in the face of such events. The African continent in particular is reeling from a number of consequences of the climate crisis. Deforestation, hurricanes, fires, droughts have all contributed to a decline in food security, an increase in water scarcity, displacement, as well as an overall denigration of the human dignity of African citizens. A key response to this issue has been the initiation of litigation linked to floods, with the sole aim of ensuring corporate responsibility for such extreme weather events through damages claims. Throughout this webinar, we will hear from distinguished experts in environmental law, corporate governance, as well as disaster management. They will share their expertise and perspectives on navigating flooding cases in their specific jurisdictions and the complexity of initiating claims in DLICT for environmental disasters generally. After these presentations, we will transition to an interactive Q&A session where you'll all have the opportunity to engage directly with our panelists. We've also made interpretation services available in French, ensuring that language does not pose a barrier to participation in this crucial conversation. Thank you once again for joining us. So colleagues, please allow me to introduce our first speaker for today's webinar. She hails all the way from New York in America. Her name is Victoria Maniatis. Victoria is a partner at Milber. She performs at all levels of bellwether trial case specific workup, discovery, as well as expert investigation. She also serves as one of the firm's dangerous drugs and devices practice leaders. She works on behalf of numerous municipal clients nationwide and has served as a practice leader in the firm's environmental and toxic torts department. She has graduated with a BA from Pennsylvania State University, as well as a JD from Hofstra University. And for over 20 years, she's focused on a number of different fields, including natural resource damages, pollution, and environmental cases. She has been appointed to serve as lead counsel, as a committee member, as well as a fee committee member by both federal and state court judges. And in 2024, she was recognized by the National Trial Lawyers as a mass tort top 25 trial lawyer, as well as a civil plaintiff top 100 trial lawyer in New York. She's been recognized as a top attorney of the New York metro area, as well as a top women attorney in the New York metro area from 2013 to date. And outside of the office, she enjoys the outdoors, is a runner and a triathlete, having competed in a number of marathons and a half Ironman race. So ladies and gentlemen, let's please give Vicky a warm welcome to the digital podium. Vicky, over to you.
Thank you, Noma. I can't thank you enough for including me in this important panel of all of you very esteemed speakers. And from New York, we want to thank you for including us because what we're talking about is truly global. So it's so important for us to all be working together, and I relish this opportunity and thank you again. At my firm, at Milber, we have been pioneering new legal strategies to combat climate change, which I want to share with you today. We have been pursuing interesting claims, including RICO, which is racketeer-influenced corrupt organizations, and antitrust counts. These strategies are proving to be game-changing in the climate litigation world. We are bypassing traditional legal hurdles of preemption issues that are posed by the Clean Air Act, and we're likewise avoiding a lot of the pitfalls in our federal court cases that are inherent with some of the state court cases by using these unique paths. By using RICO and antitrust claims, we are sidestepping these constraints that have been hindering other cases at the state court levels. The federal RICO statutes provide a powerful tool to target the coordinated efforts of these climate change deniers and polluters while holding them accountable for their collective actions. And that's really a key to what we're talking about, is this collective act, these conspiracies that they have engaged in from the beginning, if you will. Emissions, but also worldwide emissions. As there's a recent case in the United States called RJR Nabisco that has confirmed that international predicate acts are permissible as long as your damages are domestic. And that's a distinction that is important for a lot of the work that we've been doing. This strategy is crucial because it expands our reach and the scope of accountability of the polluters. By utilizing the federal racketeering and antitrust counts, we are not restricted in the same traditional way. Moreover, our approach targets, again, like I said before, that intricate conspiracy of the climate denial enterprises, which are not just the polluters, but those that are supporting the polluters in their campaign. This includes deceitful practices and concerted efforts to undermine climate science, which have profound and far-reaching impacts on our environment. By focusing on these coordinated activities, we can draw a direct line between the climate actions of those enterprises and climate-related damages that are suffered domestically. And we hope that you'll be able to do the same and say that they're suffered internationally. These claims allow us to hold these polluters and climate change deniers accountable on a global scale, ensuring they can't escape liability by hiding behind jurisdictional and preemption defenses. This not only broadens the scope of legal accountability, but also enforces our commitment to protecting the communities we represent, those we don't represent, and the environment from the devastating impacts of climate change. Now, I want to focus a bit on a few of these cases that we have brought and some of the intricate and unique qualities about each one of them. And one that you may have heard of was the climate change case that we brought in Puerto Rico. In the face of escalating climate challenges, we developed the first comprehensive conspiracy model to link global emissions directly to specific climate disasters. And here we are talking about the 2017 Atlantic Ocean hurricane season. Traditionally, climate litigation faced significant hurdles in attributing specific events to the actions of the fossil fuel companies. Many complaints that had been filed before hinted at a conspiracy without really illustrating the intricate web of collaboration and its cumulative impact on our climate. We attacked this barrier by meticulously detailing how these entities conspired, their deliberative misinformation campaigns, and the overwhelming global emissions resulting from their activities. Now, our model stood out not only because of its precision, but also for its clarity in depicting the defendants' worldwide emissions and their direct contribution to the devastation wrought by these 2017 hurricanes. The hurricane specifically that hit Puerto Rico was emboldened by massive rainfall, pouring previously unheard of amounts of water on Puerto Rico. The resulting deluge flooded nearly every part of the island, destroyed crops, fractured roadways, trapped citizens in their home, and in their homes. And for many of them, their homes were destroyed and they had no ability to leave their home areas to seek shelter or to get food or to get important medical care. And without food and medical care, clean water or transportation, there were over 4,000 deaths attributable to Hurricane Maria in 2017. By methodically accumulating and presenting this data, we provided irrefutable evidence of the link between the corporate actions and environmental consequences. Since this introduction of this pioneering model, it has become a cornerstone in climate litigation. Other legal teams have adopted our approach, some to the point that they have mirrored our complaint almost nearly exactly. And as they say, imitation is the greatest form of flattery. And this widespread adoption underscores our model's robustness and its critical role in holding the climate change denial enterprises accountable. Our conspiracy model has empowered communities worldwide to seek justice against perpetuating climate denial and has set a precedent for future litigation. By suing the climate change denial enterprise, we have taken a decisive step forward and toward greater corporate accountability and environmental justice. So now, part of what we did in this process was what we'll call a deep dive into specific damages. This is one of the things I focus on in my career, is developing damages that individuals, that communities suffer, exploring them into very great detail. When we get to work with these communities, we get to know them very well. And likewise, they get to know us very well. So what we have found is that by developing small teams or task forces that focus on particular issues and are very tailored, we find that's the best way to put the community's case forward. To give you a specific example, typically we would have 2 or 3 members of our firm would meet directly with community departments such as health and human welfare, natural resources, their departments of public works, infrastructure, budget, very important in calculating damages, and committees and departments like that. We call this boots on the ground. And with that approach, we dive deeply into their programs and their expenditures, discuss their goals for how they want to improve their community and how they want to achieve those goals. And we work together on how they can best do that, developing a model of what their damages are and how to introduce them by using world-class experts who are poised to tackle those particular losses. Frankly, it's shocking when you look at the expenditures and the losses that communities suffer and they are required to bear for so long. Often they don't even realize them anymore. They've just brought this into their daily life as to what they have to sustain. They frankly are rather numb and just pay money. And we attempt to wrong that right by going after the polluters and holding them accountable for what they should be responsible for. Let's say an example that is classic in Puerto Rico and likely I assume in Africa as well is costs for cooling. Increased costs for healthcare, then we can directly attribute this to climate change. And our model has proven effective not only in Puerto Rico, but in several of the states in the United States where we have used this model in other litigations, such as our opioids cases, same type of model that we were able to use there. And we used this model also in Brazil. So this brings me to another example that will show some unique angles that you can use and hopefully keep in mind when you're pursuing a case as to the depth of the potential for bringing cases against defendants. So what did we do in Brazil? So Brazil, we sued mining companies and dam builders. These companies, we sued them not in Brazil, but we sued them in the United States, in New York. How did we do that? Well, Vale is the company in Brazil that mined iron ore throughout Brazil. And this process produces toxic waste, and that toxic waste is called tailings. Now, instead of properly disposing of this toxic waste, Vale dumped it essentially in piles, creating dams upstream in rivers. These were very insecure, they were weak, and it was the cheapest way for them to dispose of the waste and to, of course, maximize their revenues. These dams were at risk of failure, and that failure would then mean contamination to the surrounding communities. And that is exactly what happened. These dams did fail back in 2015 and again in 2019. There remain 21 dams that are still in place. So we can rest assured, unfortunately, that there will be more failures. And that is the fear that these local residents live with every day, is the fear that there will be toxic flooding, forcing mass evacuation, displacement. And for those who aren't lucky enough to be able to evacuate, there are in fact deaths that are suffered as well. Now, what these failures did was they forced the Brazilian municipalities, the governments, to provide water, food, healthcare, and shelter for thousands of their impacted citizens. All of this while their own internal revenue is being completely depleted. They no longer have a workforce, so they are paying out and they are losing money. The human and environmental carnage that was caused by these dams under Brazilian law gives rise to strict liability, and this is the key, for any entity responsible directly or indirectly for these damages. Now, the crux of what we did was we brought our case in New York, and I'll explain that just a little bit, but it was also not where we brought it, but the way we calculated the damages. We used experts to build a damage model, calculating the costs to care for these displaced residents, calculating daily their food, their water, their shelter, and their healthcare needs. We multiplied that by the thousands of people who were impacted. We multiplied that by a per day loss to date. And then we could multiply that into the future to at least 2029, which is the time frame that Vale estimates it will take in order to repair the damages. So that is a multi-million-dollar demand figure for those losses. The second part of the loss is, of course, the loss of the property damage and the natural resources. So this was a bit of a novel strategy, and the case is getting a lot of attention. Now you're wondering about New York. Why did we bring this here? Well, because we realized that by doing some research, Vale was being funded by many lenders, and these were New York banking institutions. You've probably heard of some of them, such as Barclays, Deutsche Bank, Merrill Lynch, and a host of others. As lenders, they were also investors in Vale. And we argued that the banks are strictly liable to the Brazilian citizens. Now, New York is where these banks are headquartered, and that was the chosen venue in their underlying loan documents. So we are seeking punitive damages based on notice, because they had advance notice that this was likely to happen, did in fact happen in 2015 and 2019. And despite all of that advance notice and knowledge, they continued to fund this destructive force, if you will, knowing it is going to be resulting in destruction. So we filed this in this class action in the Southern District of New York. And there, the New York Choice of Laws rules require the application of Brazilian law. And Brazilian law adds for these additional claims that we are able to pursue under strict liability. So that is essentially, we could obviously go into greater detail, but to give you an idea of some of the creative ways we are pleading, some of the broader ways we are pleading in order to take a next level of culpable defendants who are investing in the corporations that are leading to the destruction of our environments and to additional flooding that is displacing our citizens and are significantly assisting the tortfeasors in the climate challenge. And with that, I will conclude and thank you very much for allowing me to share some of the cases that we have been bringing and are very excited about.
Thank you so much, Victoria. That's really, really interesting. And I've got some questions lined up for later on, but thank you. So we're going to move on to the second speaker. Who is Brandon Abdinor. So Brandon joined the CER as a climate advocacy lawyer in 2021. In this role, he engaged with climate change related laws and policies with a view to helping and ensure that these are effective and advance the needs of climate justice for all. The role includes liaison with a wide range of stakeholders to gather and share information, build consensus around legal advocacy in pursuit of an increasingly sound and just climate change response. Since March 2023, Brandon has been acting as the head of Pollution and Climate Change Program, overseeing all the activities at CER within that program. He obtained an LLB from the University of the Witwatersrand and was admitted as an attorney in 1998 after serving articles at Routledge Incorporated in Johannesburg. He went on to fulfill various management and legal roles in the corporate sector before opening his own legal and consulting practice in 2018, focusing on dispute resolution and sustainability matters. For fun, he enjoys freediving, yoga, hiking, and engaging with how we can create a more generative world. Without any more ado, Brandon, over to you. Thanks.
Thank you, Lucian, and hi, everyone. Really good to be here. I love these opportunities, not only to share the work that we're doing, but to hear the work that everyone else is doing. And then obviously the discussions and Q&As are always very interesting as well. And this is a relatively new field of law compared to many, so much learning to be done all around, certainly by ourselves. So I'm going to share screen and I'm going to just turn my camera off for the presentation because I've had some bandwidth issues. And then I'll appear again at the end. Okay, hopefully everyone can see that. So I'll be talking about our Polluter Pays report. So it's a report about research and research about the potential to move into this area of law more decisively, both by ourselves directly, and then also the idea, as with all the work we do, is to make the knowledge that we gain as freely available as possible for others to use. And if you're interested, you can always look at our website, which is quite a library of related issues. So the idea of looking into loss and damage is it's kind of almost a next obvious step, and will complement our existing climates, both litigation and advocacy work. We've tended to be very engaged in mitigation, and we have been mainly challenging the state on taking decisions that are harmful to the climate or inadequately assess climate impacts, and starting to look more on the adaptation and climate resilience side of things, both in Durban, which is a subject of this research report, as well as a big project, the Musina-Makado Special Economic Zone, where we challenge with expert input the inadequate climate change impact assessments as far as adaptation goes. The idea was to bring out the polluter pays principle that's in our law and is also globally recognized, and sort of make the linkage to the the context of climate loss and damage. The report looks at the legal avenues using South African law as it stands today. And as mentioned, focuses around the 2022 KZN floods, although much of these principles are obviously applicable to any severe events, slow onset or catastrophic. And the intention was also to highlight the role played by the carbon majors. But again, the list of potential plaintiffs here is obviously a lot larger than that. So using eThekwini or Durban, for those that don't know, our largest port city on the eastern coast of South Africa, where this particular flooding incident happened, or series of incidents, and just acknowledging the kind of pre-existing vulnerabilities, which is something that I think needs to be taken into account in many of these loss and damage cases. But just the fact that there are high levels of poverty and inequality, housing, service delivery backlogs, including water, sanitation, and electricity, also compounded by rapid urbanization, migration, resource and capacity challenges, management challenges, and so on. So these are all part of the matrix that need to be looked at and then disentangled to really isolate what are the climate-related damages. Durban, however, is actually also on the leading edge of certain climate resilience measures. Former IPCC co-chair Deborah Roberts was in charge of the climate department there for many years. And the city is in many cases a case study for sound action, and in particular since 2013 has been investing in rehabilitation of rivers, for example, looking at water security risks, health impacts of degraded environments, and has put a lot in place to enhance ecological infrastructure, including flood protection. And the value of some of these measures has been calculated to be up to 12 to 14 billion rand a year. So that's how much can be done working with nature. Obviously, there's a lot of human work that goes into making these projects happen, but it's not sort of like building seawalls or that level of heavy infrastructure. They're also community-based flood early warning systems using WhatsApp. So the formal early warning systems then get filtered through to leaders in informal settlements, who then filter them through to the residents. And it's estimated that this system possibly saved between 250 and 400 people's lives in this particular flood event, which is really quite phenomenal. Just looking at the events themselves, so the extreme rainfall and the flooding need to be looked at separately. Extreme rainfall doesn't always lead to flooding, and flooding can happen in certain occasions without extreme rainfall. So from a rainfall point of view, over 300 millimeters of rainfall fell in a 24-hour period. And then from a flooding point of view, obviously, again, there are all these human interventions and human infrastructure and human settlements that play a role in what happens with the flooding. So looking at paving and roads, stormwater draining, all of these things have a contribution, as well as the saturation of the ground. There've been rains leading up to this particular extreme rainfall event, and that makes it more difficult for the water to sink in. From a climate change contribution point of view, the IPCC in the 6th assessment report does acknowledge that Eastern and Southern Africa is going to be experiencing and is experiencing an increase in the frequency and the intensity of heavy precipitation. So the warnings have been there, and I think it goes back before the 6th assessment report as well. So in general terms, this was known and kind of was expected to be happening. But going more closely to the events themselves, for example, we have a collective or collaboration of multinational climate scientists that form the World Weather Attribution Service, and their intention is to come back with very rapid responses on the role of climate change in various events. So the studies are comprehensive, but they do want to be able to publish quickly. So if you like, they're an initial level of evaluation. And some of the key findings are that because of global warming, an event like this has a 20-year return time instead of a 40-year, so it's sort of likely to happen twice as frequently. The probability of it happening has doubled. And then they found that global warming intensified the rainfall event by between 4 and 8%. Now, it's worth noting that the WITS Global Change Institute, and one of our leading climate scientists there, Professor Francois Engelbrecht, has also recently concluded a modeling exercise which is currently out for peer review. And that modeling exercise found that the event was intensified by 40%. So it'll be interesting to see what comes in once that's available to be taken apart. But yeah, the indications are that with the different form of modeling, the climate change signal or climate change influence on the event was in fact a lot stronger than initially thought. As a result, we saw 443 people losing their lives, 600 schools were damaged, 26,000 dwellings. You can see all of this in the report. It's not necessary to unpack all of it, but the estimated cost is between 17 and 40 billion rand. And obviously, these are the numbers that are important when we start wanting to look at damages and apportioning those to the emitters of choice. In terms of remedies and reparations, so I'll go into this sort of strict law as it stands just now, but this was more of a blue sky exercise of what could be claimed. And we looked at it in terms of backwards looking compensation. So that's a more typical claim situation in the law of tort or delict. And that could include obviously losses of public infrastructure, homes, community infrastructure in formal and informal settings. This is one of the areas that I think needs to be looked at quite a lot, is that often when they tally up the losses, they look at kind of formal settings, formal economy, formal housing. But the truth is that the most vulnerable people in these situations are often in informal settlements, participate in what could be called an informal economy, and have social infrastructure, which again is probably not logged or measured or quantified anyway, but it's the lives of those people. Also, loss of access to services such as healthcare, education, sanitation, damage to food production resources. Very importantly, physical and mental health impacts, including individual and collective trauma, loss of access to transport, loss of a sense of place, social cohesion and stability, loss of tangible and intangible heritage, and any other environmental harms beyond the obvious and quantifiable, what many call ecosystem services. Looking forwards, and for example, I'll touch on something known as a climate super fund, which has come into being in Vermont in the US. Can emitters start being compelled to pay into funds, and can these funds be used for forward-looking climate resilience measures? And here we look at things like upgrading of informal settlements in a climate resilient manner, upgrading of formal infrastructure, public assets, and enhancing and replicating some of those interventions, such as that community-based early warning system. Because eThekwini has done so much work on this, it would be great if these models and methodologies could actually be rolled out to other metros and other areas in the country and around the world. Funds like that could also be used to enhance the creation of green jobs and a green economy, strengthen environmental conditions and ecosystem services, create support mechanisms to alleviate and prevent trauma and mental health impacts of climate change. Probably very importantly, create and maintain participatory structures such as climate assemblies, where all stakeholders can come to the table and have an ongoing conversation about what climate resilience looks like for everyone, what is needed, what would be the best interventions, which interventions are perhaps maladaptation and should be avoided. And then we ask the question, who pays? So I won't go into it much here, but just to say that the polluter pays principle is kind of globally recognized and was brought into the Rio Declaration in 1992. It's recognized in our National Environment Management Act, and says the costs of remedying pollution, environmental degradation, and the consequent adverse health effects must be paid for by those responsible for harming the environment. And as of 2 days ago, in South Africa, we have a Climate Change Act, which also brings this principle in, and that talks about the costs of responding to the adverse impacts of climate change and of mitigation must be paid for by those responsible for causing the adverse impact. So we really have this understanding and these fundamental principles which supports the idea of claiming from the emitters. Again, I won't go into this too much for this presentation, but the report introduces the carbon majors, which is really the list of the top carbon or greenhouse gas emitting entities, goes back to 1850. And if you're interested in this, it's worth looking at the Climate Accountability Institute, which has been going since about 2014. And it really lists those entities and starts to give an idea of what the pro rata apportionment could be for damages claims against carbon majors like this. The report just sort of highlights the role of the fossil fuel industry, particularly raising the fact that they knew about the potential harm coming from their products and activities. In some cases, as far back as 1959, and certainly in this 1970s and 1980s, unpacking the way in which they misrepresented, hid information, and basically greenwashed. Trying to avoid pressure to become part of the decarbonization process, and in the long term, probably trying to avoid liability. And then the report goes into the attribution science, and I'm sure this is something Victoria knows a lot more than I do, but really looking at how science can be brought in to deal with proving causation and linking the actions between, making the linkages between the actions and the harms. And there we have different types of attribution science, or different legs, if you like. So climate change attribution is kind of the obvious one, and that's the one that seeks to identify the causes of climate change at a global or regional level by understanding how human activity is driving climate change. Source attribution looks at the extent to which the warming can be attributed to specific activities or companies or entities. So starting to break down the responsibility according to the actor. The extreme event attribution, so that then looks at, and that's the information that I shared that came up from the World Weather Attribution Service, for example. How much did the global warming cause or intensify the particular event? We had big floods here in the Western Cape, not floods, sorry, droughts in the Western Cape in around 2017. And it was found that those droughts were made 3 times more intense as a result of climate change, just as an example. And then finally, the impact attribution. How much did the event cause the damage or contribute to the damage? Not all flooding, if the infrastructure is sound, social services are sound, not all flooding will necessarily cause that many impacts. But in other situations, it will cause a lot. So it's really unpacking that and being able to quantify it. Then looking quite briefly as well through the legal system as it stands today in South Africa. So this is a very high-level overview, and I think hopefully this work will lead to an institution of a claim somewhere down the line, but then we would get sort of fresh and more in-depth information. But looking at issues like jurisdiction, if we're in South Africa and we want to sue a carbon major that's headquartered somewhere in the global north, what would it need? What would we need to be able to find jurisdiction? Possibly one of the trickier aspects of instituting a claim like that, but certainly possible. And then of course, in which country would that happen? Do we want to pick an emitter or a selection of emitters and pursue them wherever they are, or do we want to choose a jurisdiction where it looks like the jurisprudence is more advanced and more favorable, and then go for whichever emitters are domiciled there. These are all questions that we would need to look at. Causes of action. So in this case, the exercise uses the law of delict in South Africa, which is known as tort elsewhere. But that would be one of the questions. And then standing. So this is not seen as being a big problem in South African law. I think standing would be relatively easily proven if one were representing a group of individuals from an impacted community, for example. Another one that's a bit more challenging, again, is parent company liability. If one's going to sue a fossil fuel major, you obviously want to be able to kind of cite the whole group and take that company's total cumulative emissions across its operations into account so that the pro rata apportionment is not too small. Obviously, then these are more sort of standard aspects of our law of delict, such as wrongfulness. Would it be reasonable to impose liability on a defendant? And yeah, this could be challenging. I mean, at the end of the day, we do know that the fossil fuel companies are selling products that are then used by everybody. But if you bring in the notion of the degree of their deceptiveness and the fact that they've known for decades, that would probably help with the wrongfulness leg. Reasonable foreseeability, and we think that one would be quite an easy one to prove. Preventability, yeah, that's going to be interesting. Would the court look at the value to society of the fossil fuel products and the fact that our systems are based on them? But again, the fact that this information has been out there for a long time, people have been pushing for alternatives, would probably be helpful there. The attribution science would be very much under the spotlight. So this is where we'd be drawing linkages that certainly in this country haven't been drawn before. And I think this is where a lot of the pioneering work is going on around the world. Again, I think Victoria would know a lot more about that. And then the causation side of things, which is supported by that. And then remedies, yeah, that would be, again, an interesting question. And going back to my earlier point of backwards and forwards looking remedies, what can reasonably be asked for and what not? And then finally, the conclusion is that there is a viable path in South African delict law as it stands. There probably would need to be some development of the common law as we go along, but it is certainly plausible that a claim could be instituted if the various challenges that I mentioned were successfully overcome. We'll also look very briefly at windfall tax. It's happened in some parts of the world, I think, including the UK, and it has been mulled here. For example, the coal industry has made very, very high profits since the Ukraine conflict began. So should those companies not be subject to a windfall tax, which could hopefully bring resources to a compensation situation? And then I think it's Vermont, as I said, and we're probably starting to see it elsewhere, this idea of a climate super fund where fossil fuel entities and large emitters are proactively taxed or have to pay a levy into a fund, which then gets used to pay for compensation and addressing climate loss and damage. And with that, I will stop for now and yeah, look forward to answering questions later. Thank you.
Thank you, Brandon. Always good to hear the South African context, particularly around the forward way of thinking and holding corporations accountable. It's always, I think, where we are with the climate crisis is always key, right? To kind of see how we can start holding them accountable in the future. Thanks for that. The next speaker that we have is Dale. So Dale Onyango is an environmental and climate change lawyer, currently serving as a senior program officer at Natural Justice. He's also an advocate of the High Kenya. Dale's work came for the rights of local communities in enhancing their participation in natural resources law with a strong focus on environmental governance. In 2024, Dale supported a landmark case filed by the Law Society of Kenya, seeking to compel the government to take positive actions to mitigate the effects of the devastating floods witnessed earlier in this year. Additionally, Dell has explored public interest litigation across various forums in both local and domestic courts, notably participating in a case such as the East African crude oil pipeline case before the East African Court of Justice. Dell, without further ado, please take it forward.
Thank you very much for the introduction, Lucian. Good afternoon, everyone. I hope you can all hear me. My internet is a bit shaky, but I hope it will stabilize in the course of my presentation. So I'm really excited to be here to share with the team some of the litigation work that we've done in Kenya around flooding. My intervention will be limited to holding the government responsible, because all of the cases that have been filed in Kenya, interestingly, have been filed against the government, and they seek to make the government, rather they seek to hold the government accountable for not taking precautionary measures during the just experienced flooding in Kenya. So as part of my presentation, I'll be highlighting 3 cases that have been filed, directly linked to flooding that has been happening in Kenya for the past 3 years. I shall also talk about the laws relied upon in court. I shall also talk about, and I think most importantly for me, is challenges faced with bringing very novel issues to Kenyan courts, because I feel that there is a gap we need to bridge as lawyers when trying to handle very new and novel cases. So that basically would be the backbone of my presentation. So first and foremost, just to pick up from where the last presenter left, it is true that East and Southern Africa has experienced extreme weather events, particularly in East Africa. For the past 5 years, we've been experiencing extreme weather events, from drought that was there from 2019 all the way to 2021. Subsequently, there was extreme heavy rainfall leading to flooding. And particularly this year, between the months of March and May, which is the long rain season in Kenya, there was extreme flooding that led to destruction of property and also, unfortunately, the loss of lives. So it's against that particular background that 3 different cases were filed by 3 different civil society organizations, primarily challenging the actions and omissions of the government in terms of presenting this particular flooding, bearing in mind that the Kenya Meteorological Department had issued early warning, but the government did not really take any necessary measures and steps to sort of prevent this flooding. And just as it was said, not all extreme rainfall leads to flooding. So there is the aspect of prevention of flooding, which in Kenya primarily, in terms of environmental rights, the state bears huge responsibility. So as we continue, so in Kenya, the Law Society of Kenya, supported by Natural Justice, filed a case at the High Court based in Nakuru. And this particular case was challenging, as I've said, the omission of the government. And it was focusing on 5 different things. One, this particular case was centered on access to information, that the government did not disseminate information on risks, prevention, response, control, and mitigation of the flood, bearing in mind that they had this information that was issued by the Kenya Meteorological Department regarding the impending flood. Secondly, the petition was also triggered by the knee-jerk reactions of the government last-minute reactions in terms of issuing directives. That was directives such as the closure of schools and directives such as resettlement of people without proper plans. Finally, in terms of the prayers, all these petitions had something in common. So they were seeking specific prayers in the sense that they wanted to compel the government to present to court for scrutiny disaster mitigation plans, emergency contingency plans to control, prevent, manage, and also to manage the effects of the heavy downpour that was experienced in Kenya. So generally, that was the main thing that were running across all these three different petitions. At the same time, some of the petitions, yet similar, the petitions tend to explore different angles. So in one petition filed by the Law Society of Kenya, the main thing was presentation of plans for scrutiny in terms of disaster management and mitigation. In another petition now filed at Nairobi by a different civil society organization, which is the Kenya Human Rights Commission, they sought for proper resettlement plans for those that were affected by the flooding. Finally, as I conclude on specifically what these cases sought to achieve, in terms of our intervention as natural justice, we realize that in almost all of these cases, they placed heavy reliance on economic and social rights, looking at the constitutional provisions. The cases also relied on the International Covenant of Economic and Social and Cultural Rights. And at the same time, the cases also focused on the Sendai Framework for Disaster Risk Reduction. So as natural justice, we also wanted to bring in an angle of climate change attribution. So we felt like there is more that the government can do considering the climate finance. And at this point, it's important to note that as a challenge, in terms of challenge, one of the main challenges or barriers to climate litigation, specifically in Kenya, and I know this runs across Africa, is the issue of attribution science. We would have loved to sort of bring in evidence to sort of attribute this particular flooding directly to climate change. But because, again, you look at how these cases have been filed from a human rights angle, it's a disaster period. And the cases ought to be concluded within the shortest time possible, because they've been filed under certificate of urgency. Sometimes it's not really possible to gather evidence that you can present to the court in view of the limited timelines that the court has given. So, for example, in the case that I was participating, the court gave us 2 weeks, 2 weeks to file all our pleadings. So you realize that 2 weeks is not sufficient enough to gather evidence to present to the court, and specifically scientific evidence on attribution of climate change, of flooding to climate change. So that is one of the challenges that we are facing with the climate litigation in Kenya. So as I proceed, we sought as natural justice to try and bring some of these evidence. And I must also say that one of the places we looked at was the Durban flooding. And I personally used the report that was just presented in order to try and convince the court that these are not really novel issues, but these are issues that have been litigated upon with proper research from different jurisdictions. I'd also like to bring to the attention of the team a different case that has been filed in Kenya. It does not specifically result from extreme rainfall, but it's also related to flooding. So in 2022, a different organization, that is Kituo cha Sheria, filed a case at the E10 Environment and Land Court. This case was very novel in the sense that it was also challenging the acts of the government, and they wanted to hold the government responsible for not taking precautionary measures to prevent the rising water level of Rift Valley Lakes. So over the past 2 years, the Rift Valley Lakes have been having, the levels have actually increased, and this has really affected indigenous and local community that are residing along those lakes. So strictly speaking, this was the first climate litigation case that was filed in Kenya. Interestingly, the petitioners requested for an impanelment of a 3-judge bench based on the novelty of this particular case, and the case is still ongoing. Again, the main challenge that this case still faces is the issue of attribution science, because based on what I've read from the pleadings, some of the respondents are arguing that the rising water levels in these lakes are as a result of tectonic movement and cannot be strictly attributed to anthropogenic activities. So as I conclude, from where I sit, it would be really interesting and important as Africans to sort of understand the sort of remedies we want when you're looking at climate litigation. So from the Kenyan angle, what we usually try and do in terms of how we craft our remedies, we usually craft them in the form of a structural interdict, where we want the court to compel the government to take some positive actions in terms of implementing some of the implementing the Climate Change Act, and also just taking measures to prevent disasters. So I'll leave it at that and hand it back to Lucian, and I'm really open and looking forward to the questions. Thank you very much.
Thank you so much, Dale. Being part of that case, that's a very, very interesting case as well. And it just shows, like, I think one thing that we're starting to see on the African continent is a lot of these new novel type of litigation cases where we can hold governments accountable. But I think the one area that's missing really in Africa is how do we hold the corporates accountable, which has always been one of the harder type of strategic litigation cases that can be advanced. Great. Well, thanks to all the guest speakers. I think we've got a couple of questions asked on the chat. So I'm going to ask Victoria. There's 2 questions here that we'll take through, and then if you could answer those, then we'll give Brandon an opportunity, and of course they'll give you an opportunity for the questions as well, and then we can take another round, and I'm not sure if we would have much time after that. So the first 2 questions, Victoria, are the first one's from Annette Gibbs from Biodiversity Law Center. She says, thanks so much for your excellent presentation and compelling content. Would you ever consider further ties of polluter enablers, specifically marketers, ad agencies, and media titles? And if so, how would you go about potentially litigating? That's just my little addition to that question. And then the second question is, has any of the cases that you discussed been concluded? What were those outcomes? How about the cost of litigation? How expensive, and who bears the cost of that litigation until there's an award?
All right. I guess we'll start with Ms. Gibbs' question. And 100%, I would consider including these additional tiers, specifically marketers. In our climate complaint that we brought on behalf of various municipalities in Puerto Rico. Our complaint is over 300 pages long. It's actually law students should read it if they're interested in climate change, just because of the extensive history that's provided in the complaint. And a vast majority of that history shows the development of the conspiracy through the big oil polluters, but how they did all that was through these marketing agencies. They were able to explode climate denial years ago before people even knew climate change was an issue. I can specifically remember some of the examples were ads that were placed in major United States newspapers over 30 years ago that were put in by major oil companies proclaiming how safe their products are, how good everything is. And this was to set the stage so that people would grow up thinking everything is fine, and then ultimately being of the side that there is no such thing as climate change. There's just a bad weather day. You know, I actually have to grit my teeth when people say things like that. So yes, our complaint is replete with examples that go through these marketing agencies, and we talk about the playbook, which was the same course that the tobacco litigations followed, was also the same thing that we did in our opioids cases. We filed against many of the marketing agencies that were using particular doctors to go out and have presentations that they were giving that were laying the groundwork for saying their long understood history of you should not take opioid products for more than a week or so was all, oh, that's not true. These are different pills. This is better. Their time release, all this theory that the marketers were putting out there. So we did sue them. Now, the caveat of what I would say about that is we ended up in the United States, our opioids litigation is focusing on, there's major settlements that have been going on for a couple of years. And these are also cases that we largely brought on behalf of governments because of lost revenues, et cetera, because of their citizens that were impacted. So there, the focus really did turn to the pharmaceutical companies and the distributing companies. So while we had those claims and we're developing them, they're not necessarily settling. And here in our climate case in Puerto Rico, again, those entities are named, but they're not defendants. I think that it may be baby steps, that at this point we're focusing on the polluters, but they certainly are not alone. And then, as you saw, what we talked about in the Brazil case with the banks, there you have that second layer of somebody who is promoting the activity by funding it and continuing to fund it. And then they're also benefiting from it because they're investors in the company. So not only are they lending them money and making money off what they're lending, they're also investing in them. So very long-winded answer to say, yes, I would say to continue to explore that second tier of marketers in particular. They're not innocent. Oh, and did you want me to answer the second question right now?
Please do. Thanks.
Yes. So no, our cases have not concluded yet. So one of the problems we have is these cases are historically taking a very long time. And we are hoping by taking the route we're taking that they're going to move faster. So that is our hope, is that they will move faster by taking this federal plan, by moving forward with the RICO claims. And the cost of litigation, yes, as you all know, this is it's very, very costly. It's why there's probably only, a handful of firms that are able to tackle this intensive, long-term type of litigation. And in the United States, the cost of that litigation is borne by firms like mine. So when we represent the communities, we have a contingency fee-based retainer that we only get paid with a positive outcome. And here we don't have that fee shift. So even with an ultimate outcome, we then recoup our expenses as part of the recovery. And if there is no recovery, there is no recovery. We have invested some great, time, resources, and financially investment too.
Thank you so much for that answer, Vicky. Interesting your opinions about the marketing cases. I know in Africa there are a number of civil society organizations that are starting to take a playbook from some of the cases that are brought to consumer tribunals, having fought misleading or false advertising when it comes to smoking, and then adapting that to the language of misleading and false advertising in the fossil fuel industry. And we're hoping to see that also start a new wave of litigation cases in the arena of consumer protection law and competition law in Africa, which I'm a huge proponent of supporting. Okay. I think now we've got a couple of questions for Brandon. I know one of them you've already sort of answered in the Q&A chat box, but for all those who weren't able to have sight of that response, I think one question was asking generally what your insights are, given the fact that this climate change bill has been signed in South Africa, and how that might impact or influence other climate issues in other jurisdictions and development of their legislation in other jurisdictions. And the second question for you, Brandon, has to do with your presentation focusing on the funding aspect when looking at a forward-looking approach when it comes to some of these flooding cases. So the question, I think, is whether or not businesses should be responsible for contributing to those funding pools or banks, or whether the state is supposed to bear the brunt of most of that funding.
Thanks, Norma.
Please go ahead.
Thanks for the questions. So the Climate Change Act, which came in 2 days ago, I don't think is going to be a silver bullet in terms of litigation for loss and damage. I think it does, its existence and the principles can be very valuable, because I think it sort of automatically or quite fundamentally demonstrates to the court that even the state acknowledges that these are issues, that there are certain principles that need to be followed, that greenhouse gas emissions reduction is a concern, and well, an imperative really. And I think all of that helps. And then there are things like carbon budgets prescribed in the Act. And I think if one wants to go after an emitter and can prove that they've exceeded their carbon budget, that would be very helpful. Conversely, if the carbon budgets are weak and the emitter has not exceeded but is still ultimately going to be pursued for damages, that's going to bring an extra layer of complexity. So the Act would be used, but we would still need to rely on the sort of General Environmental Management Act, as well as the Constitution, and then prove all of those elements of the law of dealing. So probably more helpful than not, but not, as I say, a silver bullet, and can bring in complexity. In terms of funding for future-looking climate resilience measures, yeah, I mean, it's not likely that business will hop onto this voluntarily. So I think a lot of advocacy work would need to be done. We can look at that, how that legislation was passed in Vermont, for example. We do have sort of corporate responsibility legislation and policies in the country. So I think work can be done to expand on those and bring climate within the ambit. And then obviously strongly link climate harming activities with the degree of liability to pay into a fund like that. Yeah, and that can be useful from a campaigning and advocacy point of view, that actually shows like businesses that are decarbonized and clean and low carbon, etc., are really saving costs and not having to contribute, and those that continue to pollute are going to have to pay more. But that's will still require a fair amount of work to get in place, I believe.
Awesome. Interesting. I've got a question now that you've mentioned the issue of carbon budgets. Perhaps you can answer it after we've moved on to Dale. But the question really is related to this new idea of carbon credits and companies being able to offset their budgets by buying credits from other companies who maybe have lesser emissions, and how that might affect our approach to these damages claims in instances where a corporation might say, well, yes, I'm not denying the fact that we've exceeded our emissions targets or in terms of compliance, but we also have these credits that we've bought from X, Y, and Z companies that offset all of that and the impact that would have on damages. Moving on to Dale, I think I have two questions for you. So the first question is related to, just the independent redress mechanism that might be active or operational in Kenya when it comes to holding corporations accountable. And then the second question for you is related to the fact that you mentioned in your presentations just how difficult it was to make damages the focal point of some of the petitions that you were bringing to court, because they were linked to obviously the legal factor of urgency, which limited your time period in terms of evidence gathering, but also linked to other human rights issues that needed more urgent attention at that time. Do you think we'll start to see cases after your cases that have come about at Natural Justice that will take a more strategic approach towards flooding issues? So in other words, cases that are prepared from a more long-term approach in instances where they take a couple of years to gather certain information, link it to the specific action and conduct of a specific company, and then there's an onslaught of petitions that are taken to court. Those are your questions.
Thanks a lot. Norma, very good questions. I'll start with the last one. I agree with you that I mentioned that the key issue we had was the timelines of filing these cases and the urgent issues at hand. It was during emergency times, rather crisis. But going forward, and I really, really hope this happens quite soon, that organizations would now shift to shaping the law as opposed to also reacting to this sort of crisis that we've witnessed, like the flooding crisis. So I think going forward, I'm also in conversation with different lawyers regarding just even amending provisions of the law to sort of anticipate what the government might do. Case in point, when we file all of these cases in court relating to the flooding, one issue that we had was the Attorney General coming as the respondents, challenging the jurisdiction of the court. So either one, they were saying that we did not file it in the proper court. It should have been taken to an environmental and land court. When you go to the environment and land court, it says these are human rights issues, take them back to environment and land court. So as advocates, we also anticipate that whichever approach we take, the government as the duty bearer will always be ready to file preliminary objections. So we are not just looking into filing climate litigation cases that are more long-term, but we are also looking at sometimes challenging the law in itself to enable us sort of file cases in different forums. So I believe that going forward, we shall be able to sort of just sit down and draft a proper case, look for evidence on attribution, and put it before the right court. And for the Kenyan advocates on the platform, I believe this is something that we can always pick up and finally present a climate litigation case in Kenya. On your first question, draw your attention to the Climate Change Act. So the Climate Change Act provides duties for public and private entities. That also means corporate entities. So the Climate Change Council, as per our Act, can impose obligations on private companies. The catch with that is, as of today, the enabling law for that particular provision is yet to be enacted. So I'm talking about the draft Climate Change Duties and Incentive Regulations of 2021. The Parliament is yet to sort of pass them. So as it is, the substantive laws say that the Climate Change Council may impose duties and obligations. However, there is no law to that effect to enable that provision. At the same time, if you look at Environmental Management and Coordination Act, it also talks about monitoring of greenhouse emissions. So that's also a responsibility of the Climate Change Directorate. Further still on corporate liability, if you also look at the National Securities Exchange, Environmental and Social Governance, it mandates corporate companies to present their annual social governance report. So in a nutshell, in Kenya, corporates or rather companies can be held liable. However, there is sort of a gap in terms of implementation of these particular issues, either because subsequent regulations are yet to be enacted. And I think that is the main reason why, as of now, we are primarily focusing on holding the state responsible. Thank you.
Thank you so much, Dale. I'm going to invite Brandon to answer the question now before I hand over back to Lucian.
Thanks, Noma. Yeah, on carbon credits and carbon offsetting, I guess. So, I mean, I'm sure that if one sued an emitter and obviously apportioned financial liability to them based on their emissions, I would imagine it'd be quite likely that they would raise any carbon offsetting that they've done. And that, I think, would bring in an additional layer of complexity, because then you would need to prove that the offsetting is not actually a real, in terms of causing damage, a real and effective way of offsetting those absolute emissions, which, yeah, would make a case like that a lot more complicated. But it would be lovely to bring offsetting and credits into the courts as well, and to be able to, because I don't unfortunately think it's going to go away. It's problematic. It's also a way of moving money that sometimes can be done well. But the problem is that most offsetting doesn't really actually prevent climate harm. But I wonder if Victoria's come across that aspect. But yeah, thanks.
Thanks, Brandon. I suppose we've got a little bit of time for a couple more questions. So I'm going to try and get one of my questions in. And this is more, I think it's to all three panelists, but really more geared towards Victoria. The one question is, so in Africa, we've had two major damages claim cases that have been successful, one against Shell, one against a mining company for silicosis, which impacted communities. And the question really goes around, let's say the case goes, well, we've proved everything, attribution evidence is there, and we're able to hold these polluters accountable. How do you foresee the process of enforcing that judgment, particularly since you are litigating outside of America, but within the American courts? So, like, for example, with the Shell case in Nigeria, you know, there's a court damages claim for close to $1 billion, if I'm not mistaken, to clean up the Niger Delta, to reparation claims for communities where they've been impacted, and very little movement has happened on that front. So much so that it's just status quo, still damages being felt and impacted. So it'd be interesting to see how the communities are going to be able to essentially get something out of this, because it was the point of why we litigate. And in South Africa, one way that they try to deal with it, which is the silicosis case, is to essentially set up a trust, and that trust manages that fund and pays out to communities who make those claims. But that's obviously a much more nuanced case, because it was with mine workers in a particular setting. So it's a lot easier. You know, you kind of produce your medical examination reports, and then you kind of get paid out. But with environmental rehabilitation, climate change, causation, having those links towards the damages, how do you foresee that moving forward in the future when it comes to your cases in America?
Well, you bring about a very practical question, and we have just dealt with this. As we said, our climate cases are not in a situation where we're grappling with that yet, and I look forward to that day. But I would think a parallel would be our opioids cases, where we are settling these cases with major pharmaceutical companies and distributing companies. And some of those plans, most of them, in fact, because they're paying out so many entities with very large payouts, those are structured over time. So what we don't have a trust, but what we have is a plan for each one of them where it'll be 5 years. They're paying a fifth now, it can vary. They can have a large sum up front and then smaller ones behind, a huge one at the end. That way they're able to fund the payout. And some of the cases that we have against some of the larger pharmaceutical companies, while we want to bring them to the table, we don't necessarily want to see them in bankruptcy. That doesn't serve anyone. We want them to change their behaviors. So what we have on some of those cases is payouts that are going as far as 17 years into the future. So we have seen some of those payments for some of our clients already. Some of them are into year 2, year 3, year 4. And this system seems to be working pretty well. Some of the clients, if you're a smaller entity and you're not receiving a very large sum, it can be sort of troublesome for your government to deal with that, because each little step isn't enough to really do anything. But if you're receiving a larger payment, you have enough that you can start, let's say, a recovery program or some sort of thing that you want to do in the environmental world. You want to build new structures, you want to recover losses. You can do that over time and you can plan for it. So I think that is something we're going to be seeing more and more of, and I don't know that that's a plan that would not work in climate as well. I think it's, like you suggested with the trust, it's probably the way that it'll have to go.
Yeah, thanks for that, Victoria. I don't know if Dale or Brandon, you guys had maybe a comment on that. Otherwise, I see we're running out of time, so I can close the event. Okay.
Nothing from Andrew.
Great. Well then, oh, sorry. Thanks, Dale. Thanks. So Victoria, Brandon, Dale, thanks so much for taking the time to come today and explain the various cases and the work that you guys are doing. Just to let you know, we're all part of these insurmountable amounts of WhatsApp groups that we are on, and just people messaging me on those groups saying this is such a great session, it's been so useful, I'd like to connect with the three of you. So I'm sure you don't mind if we pass your emails to those people who are wanting to connect with all three of you, and hopefully that leads to some more litigation and holding corporations accountable. I mean, I think this has been really fantastic. The perspective of what's happening in America, happening in South Africa and Kenya, it's almost like we're trying to obviously drive this change, as you said, Victoria, to make sure that we hold corporations accountable and their behavior is shifting. And I think that is happening. I suppose on the African continent, though, it is a bit slower. Just because of courts and how the court process operates. So it's a difficult field sometimes, not in South Africa or Kenya, but in other parts of Africa. So I think this is definitely going to be one of many more webinars to hold around strategic litigation and holding corporations accountable. So I'm sure, Norma, you are going to be sending a couple of emails out to see how we can get you guys back on as panelists to continue to have this exchange of information. So without any more things to say, thank you again, everybody, for participating. The webinar will be shared and will be made available on the website. So for those who did miss it or want to share it with other colleagues, that will be made available. There'll be interpretation. Hopefully, I'm not sure if we're going to be doing that yet, but hopefully we'll be able to have them interpreted in French and Portuguese, which is always great and helps our West African and Southern African colleagues when it comes to French and Portuguese. But yeah, again, thank you, everybody, and have a great rest of the week.